This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Welcome to the Luxembourg Fundcast.
Okay, welcome to the deep dive. Today we're tackling a really key document, one that's right at the core of some pretty complex deals here in Luxembourg. We're talking about the legal opinion.
That's right.
Now, you've given us a whole stack of material, notes, articles, research focusing right on this. And, well, our mission today is to help you cut through the noise, get to the heart of it. We want to give you that sort of express route to understanding why this thing is so powerful, why it can sometimes seem a bit opaque maybe, and why it's just, well, essential.
Absolutely. It's not just paper.
No, it feels like a mix of, old legal traditions and cutting-edge finance, always evolving. That sums it up well. And really, for anyone involved in transactions touching Luxembourg, investing, structuring, managing risk, getting to grips with what a legal opinion is, and maybe just as importantly, what it isn't, it's fundamental.
Right.
It's not just a box-ticking exercise. It's a serious risk management tool, reflecting the very specific legal environment we have here.
Okay, let's unpack that then. What is a legal opinion in Luxembourg, really? Because one of the first things that jumped out from the material is that it's very clearly not a guarantee.
Absolutely not. No insurance policy either. That's rule number one, to avoid confusion.
Okay.
Think of it as a formal written statement. It's where a qualified lawyer gives their professional judgment on specific legal questions tied to a deal.
So their expert take.
Exactly. A reasoned analysis based on their expertise, but also on a really careful review of the facts and the documents they've been given. The core aim, risk mitigation for the person receiving it.
Okay, risk mitigation.
Yeah. Well, it gives them a certain level of assurance. Assurance about the legal underpinnings of the deal. Things like, does the other party actually have the legal capacity, the authority to even sign this agreement?
Right. Can they actually do what they say they'll do, legally speaking?
Precisely. And are the main promises they're making, the obligations, are they legally valid? Are they, in principle at least, enforceable under Luxembourg law? But, and this is key, it's an opinion.
Not a promise.
Right. It's based on a specific set of facts under specific laws at a specific moment in time. It's not some kind of blanket protection against any future legal headache.
So if I'm, say, a bank lending money, I'd ask the borrower's lawyer for this opinion on the borrower's legal standing?
Typically, yes, or your counsel would work with their counsel to get it. And you're right, it's become almost indispensable, as the source material says, in the vast majority of significant financial and corporate deals here.
Like what sort of deals are we talking?
Oh, the big stuff. Major cross-border loans, international bond issues, complex M&A, setting up large investment funds, especially alternative funds. Luxembourg's a major hub for these.
And it's the outsiders, the lenders, the investors who demand it?
Usually, yes.
Yeah.
They need that comfort. It's like an independent check.
Yeah.
The company says, yes, we're properly set up. We can sign this huge loan agreement.
And the opinion is the lawyer saying, yes, based on our review, those fundamental legal points check out.
Exactly. It validates those core legal representations. It's that essential third-party verification.
Now, here's that phrase that caught my eye. The source material calls it a delicate transplant. What's that about? Is it likely to fail?
No, not fragile in that sense.
Yeah.
Delicate, more like requiring careful handling, careful adaptation. See, for the whole practice of using legal opinions like this in finance deals, it was largely imported.
From where?
From the common law world, mainly. Think the U.S., the U.K. It's standard practice there in finance.
But Luxembourg isn't common law.
Exactly. Luxembourg is firmly a civil law country. Its roots are deep in the French Napoleonic codes, influenced by Belgian law, too. So you had this common law practice needing these detailed opinions, and it had to be carefully grafted onto and adapted for this very different civil law system.
So transplanting a practice between different legal traditions.
Precisely. And that blend, that delicate transplant, is fundamental. It really shapes the opinion structure, the specific language used, and crucially, the limitations and qualifications. That's where you really see the civil law influence and why a Luxembourg opinion isn't identical to a U.S. or U.K. one. Understanding that origin helps explain some of the peculiarities.
Let's dig into those foundations then. First, the civil law system itself, how does that specifically shape the opinion?
Well, Luxembourg's civil law DNA is everywhere in its legal system, so naturally it shapes the opinion. How companies are born, how they operate, how they make decisions. It's primarily governed by written laws, by codes, not built up case by case like in common law.
Right, statutes are key.
Absolutely. Yeah. And the cornerstone for companies is the Law of 10, August 1915 on commercial companies, the 1915 law.
1915, that's old.
It is, but it's been amended countless times. It's actually very flexible now, a key tool for international business. But its core structure, its principles, still very much civil law. So any lawyer giving an opinion on a company's status or its power to act has to start with the 1915 law and the related codes. That's the bedrock.
And the material highlighted a specific figure in this civil law, set up the notaire, the civil law notary. What's their role? It's more than just watching someone sign, isn't it?
Oh, much more. The notaire is integral, and their work directly impacts the opinion's due diligence. For the main company types used in finance, like the Société Anonyme, the SAI, you can't even create the company without a notaire.
They have to be involved in the incorporation.
Yes. They draft and execute the notarial deed of incorporation, and that deed is what's called an authentic instrument.
Authentic instrument. Sounds important.
It's a very powerful concept in civil law. It's a document prepared and certified by a public official, the notaire acting officially. It carries a very high degree of legal certainty. It's strong evidence of the facts it states, like the company being properly formed and what its articles say.
So when the lawyer writes the opinion confirming the company is duly incorporated,
they are relying heavily on the validity of that notarial deed and any later deeds that change the articles. The notaire's authentic instruments are a key piece of the evidence trail the lawyer examines.
Okay, that links the civil law process directly to the opinion. Now, the second pillar mentioned was absolute professional secrecy. That sounds incredibly strict. How's different from, say, attorney-client privilege?
It is exceptionally strict, and the difference is huge, really critical to understand. Secret professional for registered lawyers, avocats à la cour here isn't just an ethical rule, it's fundamental public policy, and it's backed by criminal law.
Criminal law? You mean breaking it is a crime?
Yes. Article 458 of the Luxembourg Criminal Code makes it a criminal offense for certain professionals, including registered lawyers, to unlawfully reveal confidential information. We're talking fines, even potential imprisonment.
Wow.
And it's absolute. It covers all information from or about a client in a professional context. It lasts forever, even after the lawyer-client relationship ends. Exceptions are very, very few and have to be spelled out in law, like, say, mandatory anti-money laundering reporting.
Okay, criminal liability for a breach. Why is that level of secrecy so vital for issuing legal opinions?
Think about the due diligence needed. For the lawyer to give an accurate opinion, the client needs to be completely open, right?
Yeah, they need all the facts, even the awkward ones.
Exactly. Full, frank disclosure. This absolute secrecy provides that legally protected safe space. The client can share everything, knowing it's shielded by criminal law, allowing the lawyer to get the full picture needed to form their judgment and do the rigorous review for the opinion. It builds that essential trust.
So, is everyone giving legal advice in Luxembourg covered by this criminal-level secrecy? Like, what about lawyers working inside a company?
Ah, that's a crucial distinction, and one international parties sometimes miss. No. This strict secret professional, the one backed by Article 458, applies only to registered lawyers admitted to the bar here, the avocats à la cour.
Not to in-house counsel.
Correct. Lawyers employed directly by a company, known as juristes d'entreprise, are employees. They don't benefit from this specific criminally sanctioned professional secrecy regarding the information they handle for their employer.
That is a massive difference in protection. What does that mean practically in a deal?
It's critical. It means that if you need legal analysis covered by that highest level of confidentiality, especially the kind of deep due diligence underpinning a formal legal opinion that third parties will rely on, it has to come from an external avocat à la cour.
So in-house lawyers are vital, but for that formal protected opinion for outsiders?
It must be an external bar-admitted lawyer. Their communications have a different legal status regarding compelled disclosure. For anyone used to, say, broader U.S. attorney-client privilege concepts, understanding this specific Luxembourg setup is absolutely key.
Okay. The material then walks us through a typical opinion, clause by clause. It calls it a highly formalized legal instrument. Let's break down that structure. What does each bit do?
Absolutely. The structure isn't random, it's very deliberate. Each section plays a role in defining the opinion's scope and, importantly, managing the legal risks for everyone involved.
It kicks off with addressees and reliance. Why start there?
It's all about liability. Who gets to rely on this opinion? The lawyer needs to control that. By naming the specific recipients right at the start, the lawyer makes it crystal clear. This judgment is for you in the context of this specific deal and no one else.
So it stops it being passed around and used for other things.
Exactly. It prevents unintended reliance, uncontrolled use, and manages the lawyer's professional risk exposure.
Next up, documents examined. Sounds like showing your work.
That's a great way to put it. This section defines the factual universe the opinion is based on. It's a meticulous list of every single document the lawyer looked at.
Like what?
The company's articles of association, the statutes, recent official excerpts from the public registers like the LBR, minutes from board or shareholder meetings that approved the deal, the actual transaction agreements, everything.
And the point is,
The lawyer is saying, my conclusions are based on reviewing these documents. If a crucial document wasn't on this list because it wasn't provided, then any legal issue arising from that missing document is, by definition, outside the opinion's scope. It sets the factual perimeter.
then we get assumptions, hypotheses. The material says these are often misunderstood. Are they just loopholes for the lawyer?
Definitely not loopholes or excuses, though sometimes they might look like boilerplate. They're essential. They state upfront certain factual matters the lawyer is not independently verifying,
Why not?
because it's about allocating responsibility. The lawyer handles the legal analysis under Luxembourg law. The assumptions clarify which factual things they're taking as true without digging into them themselves, often because it's outside their expertise or impossible to verify practically.
Like what sort of things?
Standard stuff. Signatures are genuine, copies are true copies of originals, factual statements made by the client are accurate. The lawyer doesn't audit the client's business facts. And crucially, that any issues under foreign laws or needing foreign approvals are handled elsewhere. The opinion is strictly about Luxembourg law. Assumptions make the process workable.
Okay, now the main event, the operative clauses. This is where the lawyer actually states their conclusions, right? What are the key ones?
Yes, this is the core, the lawyer's formal legal judgments. You'll almost always find these key ones.
Okay.
First, corporate status. Confirms the company is duly incorporated, dûment constitué, and validly existing, valablement existant. Duly incorporated means it was set up correctly according to the civil law, checked against the notarial deed in the 1915 law. Validly existing means it hasn't been dissolved or struck off, checked via a fresh LBR excerpt. It confirms it's a real legal entity.
Got it.
Second, corporate power capacité. This confirms the company actually has the power, under its own rules, its articles, statutes, to enter this specific deal and do what it promises. The lawyer checks the company's stated purpose, objet social, to make sure the deal isn't ultra-vires.
Ultra-vires beyond its powers.
Exactly. Is this type of deal something the company is legally allowed to do based on its own constitution?
Third key clause.
Corporate action.
Yeah.
Pouvoir. This one's crucial for internal validity. It confirms the deal was properly authorized inside the company.
How do they check that?
By reviewing the minutes, board minutes, maybe shareholder minutes. Did they hold the meeting correctly? Was there a quorum? Did they pass a valid resolution approving the deal and authorizing specific people to sign, all according to the 1915 law and a company's articles?
Okay, internal authorization sorted. What's the fourth big one?
Valid and binding, often the most negotiated part. This gives comfort that the company's obligations in the deal documents are legal, valid, binding, and here's the tricky bit, enforceable in principle in a Luxembourg court.
In principle, why the caution?
Because, and this is pure civil law, influence enforceability is never absolute. This statement is always subject to a list of standard qualifications.
The qualifications or reserves. The materials stress these, saying this is where common law expectations can clash with civil law reality. What are they exactly?
They're not just CYA disclaimers for the lawyer. They are fundamental statements about built-in limitations on enforcing contracts under Luxembourg law.
How so?
Unlike maybe in common law where you might get an opinion saying a contract is enforceable in accordance with its terms, implying strict literal enforcement. A civil law judge in Luxembourg keeps significant power. They can interpret, sometimes modify, even refuse to enforce terms based on overriding legal principles or public policy, no matter what the contract says literally. The qualifications state these inherent limits up front. They manage expectations, especially for international parties. They map the boundaries.
Okay, so what are the really standard must-have qualifications?
You'll always see these. First, insolvency. Enforceability is always subject to bankruptcy, fail-like, judicial reorganization, judiciaire, and similar laws affecting creditor rights.
And the material said this one needed an update.
Yes, critically important. The Business Preservation Law of 7 August 2023 fundamentally changed things here. It introduced major judicial reorganization options alongside traditional bankruptcy. So, that qualification must now explicitly refer to this broader range of insolvency and restructuring proceedings to be accurate. Just mentioning bankruptcy isn't enough anymore.
Got it.
What else? Public policy, ordre public, a cornerstone of civil law. Courts won't enforce anything manifestly against Luxembourg's core public policy. Think enforcing something illegal or utterly unconscionable.
Makes sense.
Then, general principles of law. This covers concepts like good faith, bonne foi, reasonableness, and prohibiting abuse of rights, abus de droit.
What does that mean practically? Bonne foi.
Good faith. It means a court might stop someone enforcing a contract term perfectly legally if doing so in that specific context is clearly unfair or unreasonable. Or under abus de droit, they might stop someone using a contractual right just to harm the other party maliciously. These principles give judges flexibility that limit absolute contractual certainty.
Interesting. Any others?
Yes, procedural rules. Enforcement depends on following Luxembourg court procedures, and certain remedies, like forcing someone to actually do something, specific performance, are often up to the judge's discretion. And finally, choice of foreign law. If the contract says, say, English law applies, Luxembourg courts usually respect that. But the qualification notes they won't if the choice wasn't made in good faith, or if applying the foreign law would violate fundamental Luxembourg mandatory rules or public policy.
So the opinion really is like a map. It confirms the main features, but also clearly marks the known hazards, the insolvency swamps, the public policy mountains.
Exactly. That map analogy works well. Documents examined is the territory surveyed. Assumptions are nearby areas you're relying on reports about. And qualifications are the unchangeable landscape features legal systems' inherent rules that any enforcement journey has to navigate. It protects the lawyer, sure, but critically, it informs the recipient about the real legal terrain.
Okay, we understand the what of the opinion, but how does it actually get made? Let's get practical. Who does it, how, when, and inevitably, what does it cost?
Right. The who, we've covered this, but it's crucial. For the formal opinion relied on by third parties, it has to be a registered Luxembourg lawyer, an avocat à la cour. They're bound by the bar rules, including that absolute secrecy.
And the how is that due diligence process.
Yes, a rigorous, systematic process. It's not just a quick read-through.
Can you break down those due diligence steps again?
Sure. First, corporate records review. Deep dive into the constitutional docs. Original notarial deed, all amendments, also needing a notaire, consolidated articles. Checking the legal form, the purpose, objet social, the internal rules.
Okay. Step 2.
Public registry searches, getting fresh, official excerpts from the Luxembourg Business Registers, the LBRRCS. This confirms existence, registered office, current directors, managers, and crucially, checks for any ongoing bankruptcy or dissolution notices. Might also involve checking the beneficial owner register, the RBE. Review of corporate authorizations. This is checking the internal green light for this specific deal. Reviewing board minutes, maybe shareholder minutes. Were meetings called correctly? Quorum met? Valid resolution passed? Were the signers properly authorized? All checked against the 1915 law and the articles.
And the final step.
Review of the transaction documents. The lawyer needs to read the actual loan agreement, purchase agreement, whatever it is, to understand the specific obligations the company is taking on, because the opinion speaks to those obligations.
And the material mentioned an interesting side benefit of all this digging for the company itself.
Yes, often it forces a valuable corporate housekeeping exercise. To give the lawyer the documents, the company has to find them, check them. This frequently uncovers things, maybe a missing signature on old minutes, an outdated filing.
So it helps them clean up their act?
Exactly. It can be a bit painful, add time, but it forces them to fix historical glitches, tidy up records, improve their overall governance hygiene. It's like an unexpected corporate health check.
No. Is the opinion just drafted and signed off? The material said negotiation is common.
Oh, almost always negotiated in serious deals. It's rarely accepted as first drafted. The company's lawyers draft it, send it to the recipient's lawyers, say the bank's counsel.
And then they argue about commas.
Sometimes, maybe. but usually it's about more fundamental things. It's really about risk allocation. The recipient's lawyers will push for broader confirmations, maybe try to weaken the qualifications. The giver's lawyers will defend the standard wording, especially on qualifications, to reflect Luxembourg law accurately and manage their firm's liability.
What are the typical battlegrounds in that negotiation?
Key points are often scope. Recipient wants confirmation on a wider range of laws. Giver wants to limit it to the core relevant ones. Factual qualifiers, things like material litigation or to the best of our knowledge. Giver includes these for facts they can't fully verify. Recipient might try to remove material or tighten the knowledge standard. And the big one, assumptions and qualifications. Recipient's counsel might challenge if an assumption is needed or argue a standard qualification should be deleted or narrowed. Giver's counsel defends these as market standard and legally necessary. The final text is that negotiated balance.
And the €1,000,000 question, or maybe less, the cost. Is it a fixed fee?
No official price list for legal opinions here. Fees are agreed between the law firm and the client.
So what drives the final bill?
Several things. Complexity of the deal is huge. Simple loan versus multi-jurisdictional M&A. Big difference. Then, time spent. How many hours did the team put into diligence, drafting, negotiating? Most firms bill hourly. Also, risk and responsibility. A higher value, higher risk deal usually means a higher fee, reflecting the firm's potential exposure. And, of course, the lawyer's experience level affects their hourly rate.
How is it usually structured? Hourly rates?
Typically, yes. Different rates for partners, associates, paralegals, often a retainer up front. The final invoice shows fees based on time, plus disbursements, admin costs, often a percentage of fees, plus VAT, currently 17%. Any initial estimate is usually just that, an estimate, not a fixed quote.
And how long does this whole opinion process take? Days, weeks, months?
It really varies. Could be a few days if everything is simple and the client is super organized. Could be weeks, even longer for complex deals. The single biggest factor, as the source material points out, is the state of the company's records.
If their paperwork is perfect, it's faster.
Much faster. If the lawyer finds gaps, errors, missing minutes during diligence, then time is needed for the company to fix those things before the opinion can be finalized. Then you add in the time for negotiation, which can be quick or quite drawn out. It all happens alongside the main deal, usually aiming for the opinion to be signed right at closing. So maybe a week or two for something simple, but potentially woven into a deal process lasting months for complex M&A.
Okay, moving towards the present day. The material really highlights how regulations are actively changing the game for these opinions. What's the biggest driver right now?
Without a doubt, it's the EU's Digital Operational Resilience Act, DORA. That became directly applicable everywhere, including Luxembourg on January 17, 2025.
DORA, digital resilience. Why does a tech regulation impact a legal opinion on, say, a loan?
Because DORA imposes strict, legally binding requirements on financial firms for managing their ICT and cyber risks. It makes it a board-level responsibility. Crucially, it has very specific rules about the contracts these firms have with their third-party tech providers, think cloud services, critical software vendors.
And if they don't follow those rules,
non-compliance could potentially affect the validity or enforceability of those tech contracts. And since opinions often need to cover the enforceability of key contracts underlying a transaction,
a failure under DORA could impact the legal opinion.
Precisely. It introduces a new layer of legal risk related to technology reliance. And Luxembourg's regulator, the CSSF, acted quickly. On April 9, 2025, they issued new and updated circulars to implement DORA locally.
Okay, tell us about those CSSF circulars. What do they do?
The key ones are the new circular CSSF 25882 and the amended circular CSSF 228806.
25882. What's that one for?
That's the main DORA implementation circular for CSSF-supervised firms. It gets practical. Mandatory prior notification to the CSSF for deals involving critical ICT functions. A very detailed annual register of all ICT third-party providers that has to be submitted to the CSSF. And specific new rules for cloud computing, including appointing a dedicated cloud officer.
Okay, and the other one, 22806, that was an existing one.
Yes, 22806 was the general outsourcing circular. It got amended by Circular 28883, and this creates a kind of dual-track system, which is important.
Dual track? How so?
For firms covered by DORA, the amended 22806 now only applies to their non-ICT outsourcing. All their ICT outsourcing and third-party tech risk falls under DORA and the new 25882. But for financial firms not in DORA's scope, The amended 22806 still covers all their outsourcing, including ICT.
Wow, okay. So you need to know first if the entity is subject to DORA to know which set of CSSF rules applies to their tech contract.
Exactly. It adds complexity. If you're opining on a deal involving a DORA entity's tech arrangements, your due diligence now must check DORA and 20882 compliance. Opinions will likely need new specific qualifications related to DORA risks.
The source material had a comparison table showing the differences. What are the main practical distinctions for ICT between DORA and non-DORA firms now?
Yeah, the table makes it clear. Governing rules. DORA 25882 versus amended 22806. Scope. DORA covers all ICT services. 222806 focuses on ICT outsourcing. CSSF notification. DORA needs prior notice for critical important functions. 22806 needs it for material outsourcing. Register. DORA mandates a detailed annual submission to CSSF. 22806 requires a register available on request. Contract clauses. DORA Article 30 dictates specific clauses. 22806 has its own set. Cloud rules. DORA is more specific, mandates a cloud officer. 22806 requires good governance, but not that specific role. It really highlights the new regulatory layer DORA adds.
So DORA is the big one. Any other recent legal changes impacting opinions?
Definitely. The insolvency law modernization is huge. That business preservation law of 7 August 2023, effective November 1st, 2023, it brought in those formal judicial reorganization procedures. That directly affects the standard insolvency qualification. As we said, it must now cover these new procedures, not just bankruptcy, because they impact creditor rights differently. That qualification needs to be broader now. And the material also flagged tax law changes. Now, opinions usually carve out tax advice, but things like the corporate income tax rate dropping slightly for 2025 or changes to the minimum net wealth tax, they're part of the overall legal and financial context transactions happen in. Lawyers need to be aware of the whole picture.
It really sounds like the whole environment is just getting more layered, more complex, not simpler.
Absolutely. That's a key theme from the source. This rising complexity EU regulations like DORA, domestic reforms, it puts a real premium on getting advice from experienced local counsel who live and breathe this stuff. The opinion is valuable as that snapshot in time, but only if the person taking the picture knows how to use the camera in this changing light,
So with all this accelerating change and complexity, where does this leave the legal opinion? What's the future look like?
Well, the trends identified are pretty clear. Ongoing complexity and increasing specialization. The opinion isn't going away. If anything, its role evolves.
Specialization, like opinions focused on very specific new areas.
Exactly. Think about the huge focus on ESG, environmental, social governance. As EU rules like SFDR and CSRD embed sustainability criteria deeper into finance and corporate reporting, you could see demand for opinions specifically confirming the legal status of ESG commitments and contracts or the compliance of green financial instruments.
Makes sense. What else?
Crypto assets. With MiCA now regulating the EU crypto market, expect opinions needed on the legal classification of specific tokens under Luxembourg law, or whether a crypto service provider meets MiCA's requirements. And data protection GDPR. In complex deals involving lots of cross-border data, opinions confirming GDPR compliance for specific structures might become more sought after.
And DORA's impact isn't finished yet.
Not by a long shot. The material notes the European regulators are still finalizing the very detailed Level 2 rules under DORA Gorsan. Each new standard adds more specific obligations, more detail, more potential legal tripwires. That means ongoing adjustments to due diligence, to contracts, and yes, to opinion qualifications. DORA's ripples will be felt for a while.
So, bottom line, despite, or maybe because of all this swirling complexity, the legal opinion remains essential.
Absolutely. The conclusion from the material is clear. The increasing complexity makes the opinion more indispensable, not less. It's that vital tool for managing risk and achieving legal certainty in Luxembourg's busy financial center. That delicate transplant actually took root very successfully. It works. The key now is for everyone involved, issuers, recipients, lawyers, to understand its purpose, respect its civil law limits, and rely on sharp, local experts to navigate the constant evolution.
Wow. That was quite the journey through the world of Luxembourg legal opinions. From understanding their roots as that delicate transplant fitting into civil law through the nuts and bolts of how they're built, the crucial meaning of qualifications, right up to navigating today's waves like DORA, it's so much more than just a formal document. Hopefully this gives you, our listener, a much clearer view of what they are, why they're so critical, and the sheer amount of work involved.
It really is fascinating, isn't it, how this one document reflects so much. The meeting of different legal systems, the pace of market practice, the impact of massive regulatory shifts like DORA, it really underscores that staying ahead in finance means getting to grips with these fundamental legal building blocks.
So what's the takeaway for you listening? Maybe it's just approaching the next legal opinion you see with a bit more insight into what it's really saying and what it isn't saying, or perhaps just appreciating the complex choreography that goes into producing one for a major transaction.
And maybe a final thought to leave you with. In a world where finance, technology, and regulation are constantly reshaping each other, how will this core function providing legal certainty through expert judgment continue to adapt? How will opinions grapple with validating things we haven't even fully imagined yet?
This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Hit that like and subscribe button. It was the Luxembourg Fundcast for you today.